Hello, everyone. Welcome to the Environmental Law Institute's fourth session, Summer School 2025, The Basics of Energy Law and the Energy Transition. I'm Madison Calhoun, Senior Manager of Educational Programs here at the Environmental Law Institute. We're so excited to see you here today. If you are not familiar with our Summer School series, it is a series that ELI holds each summer offering an introduction to the legal and policy foundations of environmental protection in the United States. We have 4 sessions that will be hybrid this year that are taking place every other week at ELI's office in Washington, D.C. We'll have another in-person session next week about climate change. We also have 4 online sessions this year taking place every other week as well. The series is completely free and open to the public, and all sessions will be recorded and uploaded to ELI's YouTube page for the public to watch later. So if you miss any portions of today's program or any other sections of summer school, you're welcome to watch the recordings back on our YouTube page. During today's program, we will be saving time at the end for audience questions, so please submit any questions that you have for our speakers anytime through Zoom's Q&A feature. We also have the chat open today, and you're welcome to post any observations or converse with one another in the chat, but if you have a question that you wish for our speakers to address, please do submit those through the Q&A feature, not the chat. Thank you all so much for being here today, and I'm now going to go ahead and introduce our wonderful moderator, Dr. Kristoffer Svendsen is the Assistant Dean for Energy Law at the George Washington University Law School. He has a Bachelor of Laws and Master of Laws from Bond University, Australia, specializing in public and energy law. He also has a Master of Laws in Russian oil and gas law from MGIMO University, as well as a PhD in law from the Arctic University of Norway. Before arriving at GW, Dean Svendsen worked as the Assistant Director of the Tulane Center for Energy Law, Associate Professor at the University of Stavanger, as an Associate Member of the Aberdeen University Center for Energy Law, of Counsel at a Moscow law firm, and a visiting scholar at Duke University Law School. So thank you so much for being here today, and I'll hand things over to you. Thank you all.
Thank you very much, and welcome to this session. We have the basic energy law and the energy transition as our topic, and I have 3 panelists that are going to help us get through that topic. The first one is Brian Stockton. He is the head of federal and regulatory affairs at Ørsted. Then we have Samir Doshi, the senior attorney at Earth Justice, and then Travis Annatoyn, counsel at Arnold and Porter. I'll give a quick introduction of each one of them, a little background, so we can see where they're coming from, and then I'll say a few words about the topic before we start with Brian's presentation. So Brian is the Senior Director of Federal and Regulatory Affairs at Ørsted. Brian has almost 2 decades of experience at the intersection of renewable energy and environmental law and policy. In his current role, Brian advises business units on evolving federal tax, environmental, energy policies that impact Ørsted's portfolio of North American projects. His team also develops and executes strategies to minimize risk and advocates for laws and regulations that facilitate a reliable, affordable, cleaner energy industry. Before coming to Ørsted, Brian worked as counsel at an international law firm in Washington, D.C., where he handled environmental and energy regulatory litigation and transactional matters. Samir is a senior attorney with Earth Justice Clean Energy Program in Chicago. Samir has litigated cases before the state utility commissions of Illinois, Indiana, Michigan, and Alaska, plus the Federal Energy Regulatory Commission, FERC. In 2022 and 2023, Samir was appointed volunteer member of the Illinois Energy Transition Workforce Commission. Prior to joining Earth Justice in 2019, Samir worked for 7 years in Illinois state government with the Illinois Attorney General's Public Utilities Bureau and Illinois' Power Agency. He was recognized on the Midwest Energy News 40 Under 40 list for 2019. And before that, Samir worked at private law firms focusing on energy finance. Travis is a former deputy solicitor for energy and mineral resources at the U.S. Department of the Interior, has over a decade of environmental experience as a litigator and policymaker with the federal government and in the nonprofit sector. As deputy solicitor, Travis was responsible for overseeing the department's litigation, rulemaking, and other actions under statutes such as the Outer Continental Shelf Lands Act, the Mineral Leasing Act, the Geothermal Steam Act, and the Mining Law. He worked closely with leadership throughout the department and the executive branch on administration priorities, including critical minerals, geothermal energy, offshore wind, and implementation of the Inflation Reduction Act and the Infrastructure Investment and Jobs Act. So we have these three panelists, and we're going to look at three topics. In the first presentation, we'll look at the development of renewable energy and how commercial and legal drivers play into the development of, for example, a wind farm. On the second one, we'll dive into electric power markets, RTOs, and project connection. And at the end, we'll look at oil and gas and its place in the energy transition. Just a quick note on the energy transition, since that's in our title. And the concept of energy transition, this idea of rapidly phasing out fossil fuels and replacing them with renewables, is a misguided and counterproductive framework for addressing climate change and energy needs. The reason why, if you look at Caroline Kisson at NYU's recent article, the reason why the energy transition is failing is because we have fossil fuels still supplying over 80% of global energy. Consumption of oil and gas has increased, particularly in developing economies, and coal consumption reached record highs in 2023. Global energy demand is increasing annually by 2-3%, driven by population growth, economic development in the global south, and new technologies like AI and electrified transport. Renewables alone cannot necessarily reliably meet this escalating demand. We have technological advancements such as fracking has made hydrocarbons cheaper and more abundant, reinforcing their role in the global energy mix. We have energy-intense industries like aviation, shipping, and heavy manufacturing which remain heavily dependent on fossil fuels as renewables struggle to meet their specific needs. We have permitting process for nuclear and wind power that is slower, and many countries have not implemented a tax system to discourage fossil fuel use. We have a premature embrace of the energy transition, particularly in Europe, which has led to increased energy costs, weakens the economic performance, and compromised energy security, as we saw in the continent's past dependence on Russian gas. And a word that has been launched instead of the energy transition is to focus more on energy coexistence, which talks about how the energy consumption will continue to rise and how fossil fuels and renewables will play an increasing larger role. So just as a note to that on the word energy transition, I'm going to hand it over to Brian Stockton. Thank you, Brian.
Great. Good afternoon, everyone. For those that are suffering through the heat wave wherever you are, ensuring an abundance of reliable, affordable energy is more important than ever. I'm going to present for the next 20-25 minutes or so the perspective of a renewable energy developer in the United States, looking at a number of the policy and legal drivers as we approach the market and building out a portfolio. All right. So you want to build a wind farm, storage, solar, or maybe more professionally, just some reflections on select topics that we can dive into. A brief overview of what I want to touch on. Just we covered a little bit of an intro. Maybe I thought before we go into the three panelists and the three presentations, I'd give a quick overview, just sort of the state of the energy transition, to double click on a few of the trends that Chris had mentioned. I want to talk about, maybe there's a number of considerations. I want to just maybe focus in the limited time we have on two. One, as it relates to the tax credits and how they drive investment or haven't driven investment to date. And then some additional permitting considerations as it relates to permitting renewable projects on private and public lands. But first, I'd like to do a pop quiz. We're talking about the energy transition. We should maybe just take a step back and assess where we are at this point in time. So whether it's in the chat, whether it's in your own office or living room, I'd just take a second, think about, unless you know, what percentages sort of the domestic electric power mix was for the last 12 months. So this is EIA data ending in March of 2025. So for coal, for nuclear, for gas, for wind and solar and hydro renewables. All right. Coal was at 16%. Nuclear was 18%. Gas was at 43%. Wind and solar and hydro together. So for the first time, I believe, renewables exceeded coal as part of the overall U.S. generation mix. Sort of, it's sort of one of the inflection points. So, that may be while I think Chris mentioned, fossil fuels. There are certain different trend lines within fossil, with gas expanding and coal declining. All right, second question. This one was interesting when I looked it up. What was the first year that a majority of Americans had access to electricity in their homes? 1910, 1915, 1920, or 1925? We have one guess for 1915, 1910, 1925. All right, looks like we've got a lot of guesses for the end, the Roaring 20s. And that's correct. It was actually 100 years ago. 2025 was the first year that a majority of Americans had access to electricity in their homes. All right, the last question, we'll be talking, at least as it relates to some of the tax credits, kilowatt hours, talking about megawatts and gigawatts of capacity. How many average homes can a megawatt power in a year? 250, 500, or sort of, oops. Sorry, I'm trying to control my screen and can't go back. Well, it's actually a trick question. Thank you. It's actually a trick question because it depends on a lot of factors. It depends on the source. It depends actually where you live. If you're in the South, more air conditioning, it actually powers fewer homes. So it's several hundred homes, and sort of depending on where you live, your RTO, your energy source, it's a range. But usually somewhere between about 400 and 900 homes is the most common response. Okay, let's get into the substance. We're at a couple inflection points. We've seen pretty stable but low growth in energy demand over the past decades, increasing about 2% a year. We've seen very recently that power growth through 2030 and beyond into 2040 is expected to grow quite rapidly. And according to estimates from industry analysts, including S&P Global, it's an estimate of 35 to 50% increase in demand through 2040. And in particular, the next 5 years of this decade could see a supply and demand imbalance due to limited short-term additions to the grid and increased electrification, increased AI use, and data centers, which can be built and come online much more quickly than new generation can. So by some estimates, about 80 gigawatts of annual capacity additions to the grid are needed over the next 2 decades. So that's to meet new demand and to replace older plants that are being retired. So this is sort of the inflection point, sort of where we are right here. We can sort of see we're about to go up. And so there's this increase in demand for energy. And it's also a time of increased policy uncertainty, which makes it harder to build out large infrastructure, complicated infrastructure, interstate infrastructure, like the grid and new generation. So sort of a varied supply strategy, a lot of policy reforms are going to be necessary to meet this demand. And I think, as Chris said, this is a panel about energy, energy law and the energy transition. I'd also say that it's really a time, maybe less of transition and more about energy expansion. And we've seen that while the share of renewables are increasing rapidly over the past few years, the demand is really great. So now to dive in a little bit about building a renewable energy project. So again, all the views are my own that will be expressed here. The photos are Ørsted's. And so we work on a portfolio of solar, onshore wind, battery storage, and offshore wind. We're the world's largest offshore wind developer, but actually in 2024, we are also in the US, the second largest solar installer by capacity. And there's a range of strategies depending upon which market you serve and what technology you use. But for renewables, and I know Samir will talk a little bit more about regulated utilities and regulated markets in his presentation. For developers like us, power purchase agreements are still, or long-term offtake agreements are still very critical for financing projects and going into development. So these power purchase agreements, or PPAs for short, they involve a payment from a buyer or an offtaker to the operator of an energy project like us that can typically last for a decade or 2 decades. And really, for renewable projects where the fuel is free, it's really capital that's the fuel and the cost. And investors, whether we're going to debt markets or trying to get tax equity or other financing, everyone hates risk. And how do you mitigate that risk? It's by showing this long-term offtake. And it's a little bit different depending on the types of projects that you're building. So just at a very high level, you can think for onshore projects like solar, voluntary PPAs from corporate buyers. That's a very common mechanism. They may also have, in certain markets, compliance purchases from utilities. They may be subject to state clean energy standards or procurement requirements and are looking to supplement their generation capacity. PPAs can be physical, so actually delivering energy at the bus bar. They can be virtual, where you're adding power to the grid, but you're contracting with a company, and that really is more like a contract for difference or a price hedge. And at the end, oftentimes the duration of the project will extend beyond the PPA. So the PPA may be necessary to acquire the financing to build the project. If it's, say, a 15-year term, your project may have a 25-year life. A developer then after that can sort of sell power on the merchant market after the PPA expires. On the offshore space, it's a bit different. These are larger projects, usually 600, 700, 800 gigawatt plus. So we're thinking about almost like a nuclear power plant worth of energy. There's no corporate PPAs yet. Just sort of given the size, given the it's not commoditized in the same way that solar is yet. So to compensate for that, select states have established procurement regimes, usually in the Northeast, Mid-Atlantic so far, to have competitive solicitations. And these offer a fixed price. Maybe there's a inflation or some other adjuster, but it offers a fixed price for a period of time. And it's that term that then allows the developer to obtain the financing to build that project. Usually, and I think you've seen the headlines. The mechanism here is there's a tension between having the offtake upfront with that price, and then taking years to permit and construct a project. And the developer often will bear that risk of increased costs that can happen sort of before a project is placed in service. And there can be several years and many things that can happen in between that time. So I talked a bit about why the PPAs are necessary to access tax equity. And so I want to now focus a little bit on the role of tax credits in financing the energy transition as it relates to renewable energy projects. So again, lowering that cost of capital, that cost of capital is a key constraint to deployment. Wherever we raise the money to, the billions of dollars to invest in new projects, the investors assume, there's sort of a weighted average cost to that. And we have to beat that in order to keep investing. Tax credits effectively lower the cost of new investment, and that allows greater reinvestment then into new projects and faster deployment of clean energy technologies. There's a range of clean energy tax credits, biofuels, wind, solar. The Inflation Reduction Act of 2022 extended, consolidated, and created a number of new tax provisions for eligible renewable energy and other clean energy facilities. The two ones that I want to talk about in this presentation are elements of the old sort of production tax credit, or PTC, and the investment tax credit, the ITC. And those are under sections 45 and 48, respectively, of the Internal Revenue Code. So starting in January of this year, in 2025, all wind, solar, and storage systems, for an ITC, if they have an anticipated greenhouse gas emissions rate of 0, they're eligible for these tax credits. And there are separate production tax credits for other technologies. But the new piece here for the renewable side is that it's technology neutral. So really the one component here was, rather than having a separate credit for wind or a separate credit for solar, different rules, the intent was to move to a more universal tech neutral approach. We also live in interesting times. This is all sort of subject to change. Congress is currently considering revisions to the clean energy tax credits, but this is the framework as it exists today. Eligible taxpayers can deduct, so taxpayers being developers like us, can deduct a percentage of the cost of that renewable energy system from their taxes, or critically, through transferability, they can transfer them to other parties and monetize that value. And that's important in order to allow more rapid reinvestment in new projects. There's also additional provisions where certain tax-exempt entities, tribes, local governments that may not have tax appetite, they can also receive a direct payment if they're building renewable energy projects. So the two credits, Section 45Y, Section 48E, the first is a production tax credit. It pays out over 10 years, and it's based on the electricity that's produced. And again, it's important to recognize that none of these credits apply until a project is actually connected to the grid, placed in service. So there's nothing that's received up front. There's a base credit of 0.5 cents for every kilowatt hour produced. And then if a developer meets certain wage and apprenticeship requirements, that can be increased to 2 3/4 cents. Then there's additional bonuses. If a developer uses sufficient domestic content, or if a project is located in a designated energy community, that could be a brownfield or certain census tracts where there might be coal plant closures or certain demographic changes over time. Again, this was intended to aid in the energy transition where maybe older fossil generating assets were being retired, and it would encourage investment in those areas. Section 48E is an investment tax credit. So that's taken, rather than being paid out over time, it's taken after a project is placed in service. It also includes energy storage facilities. There's a base credit, and then with wage and apprenticeship requirements, it goes up to 30%. And then with the option, if you can meet, and these are difficult thresholds, if you can meet certain domestic content or energy community requirements, there are additional bonus credits to those. And again, if you look down at the definition of this qualified facility, they are looking at, the trigger is really about this greenhouse gas rate being not greater than 0. So moving away from individual technologies. I should note today is June 24th, and this slide may very well be out of date, in a month or two. I do want to flag something for those that may be paying attention to the news. There is a difference between start of construction versus placed in service. And these are concepts that could apply for renewable energy. They could apply to nuclear. There are also credits in the Inflation Reduction Act for carbon capture, for advanced nuclear, for traditional nuclear. These concepts are fairly similar. And it's really about certainty. As we talked about earlier, a developer wants to de-risk. And for a number of these projects, they could require hundreds of millions or billions of dollars of investment up front. In order to do that, the taxpayer wants to know that if they make this investment, if they take a final investment decision, that they can claim a credit when the project is placed in service. And again, we talked about that gap between making the investment decision, getting the components, going to construction, and then placing it in service. That can be several years. So historically, for the old legacy ITC and PTC, eligibility depended upon whether the construction on a qualified energy property began before a specified date. And that's important because you could know that as long as you began construction by a date, you didn't have to necessarily place it in service, which is harder. If anyone has tried to have a contractor do work on your house and nail down a particular date, it's hard to do so. And then navigating a complicated permitting process, interconnection issues, supply chain constraints, that's difficult. It's important because you can only take that credit, you can only claim the credit in the year that the eligible facility is placed in service. So that can mean when the taxpayer begins depreciation, or when the facility is, there's a number of factors. The IRS looks at 5, none are really dispositive, but it's really when you're able to connect power to the grid. And it's serving its intended designated function. Congress is debating these issues right now. And you can look, this chart just shows they're just hypothetical ways that are being debated about how these credits could phase down over time. Currently, under the Inflation Reduction Act, the credits would phase out starting in 2032, or when a greenhouse gas reductions meet a certain threshold. I think that very well may change. But again, the point being is whatever you have these dates certain, it's critical to remember whether it's starting construction or placed in service, determining eligibility. From a risk perspective, it's night and day. So we've covered at a very treetops level some of the tax considerations. Now we think about permitting considerations. There's a host of multiple statutes, multiple agencies. I'm going to focus a bit more on the federal side, but the hurdles that a developer jumps through really depends on whether a project is being sited on private land or on public land. If a project is on private land, and many, though not all, onshore solar, wind, and storage projects are on private land, there may be a NEPA hook, but depends on the size of the project, and it depends on the types of impact. It may be that the Endangered Species Act, the Migratory Bird Treaty Act, there may be Clean Water Act concerns of jurisdictional waters. There may be lighting or marking components. But the one development that we're seeing a lot of activity on private land is local siting ordinances. So there's a wide disparity among states on even whether a state will preempt local ordinances. Some states preempt local restrictions on oil and gas. Some states are passing laws to have setback requirements. Numerous counties are considering a number of restrictions, and it's a real patchwork of local ordinances to really navigate. On the public land side, it's a lot of the same considerations. There's obviously the local ordinances where if there's a intertie line or some component of your project, but there's a definite NEPA hook if you are on public lands. There's often increasingly an initial programmatic EIS, and depending on the size of the project, like say for offshore wind, for instance, there would be project-specific environmental impact statements. And these can take and do take several years to complete. There's usually a lot of work that goes in on the front end to identify the right site, but there's not enough information at that early stage to complete the environmental review. So there's still the need, obviously, for project-specific EA or EIS. There's a lot of talk about permitting reform and on NEPA and changes to NEPA. But I think from what we've seen in permitting and energy development, it's a lot of the substantive statutes outside of NEPA that really, in this energy transition, have required the most thought and how to think through and update and evaluate. So that might be, the National Historic Preservation Act. It might be the Marine Mammal Protection Act, certainly Endangered Species Act, even air permits. So there's a number of other substantive statutes that are interpreted by other agencies that may not be the lead agency conducting the NEPA analysis. And it's that interplay that makes permitting on federal lands certainly possible, but much more complicated. There have been efforts underway over the past several years to give the lead agency a bit more control, to have certain projects can be designated as a Fast 41 project. There is a FIPSI, Federal Permitting Improvement Steering Council, has dashboards to publicize dates with the idea that if you're more transparent on data about permitting timelines, we can see some marginal improvements there. But the long and the short is that permitting still remains a significant time-intensive process, and at the end result is a very robust record. There are different statutes, FLPMA for onshore projects on public lands, certain onshore public lands, and OXLA for offshore. I think Travis is going to talk a bit about those statutes in more detail in his presentation. But it's a significant challenge. And I think with that, I'm a little over 20 minutes, and I will pass it over to the next speaker. Happy to take questions at the end. Oh, one last bit. I'll just show an iteration. Maybe I'll show a picture. This is just an example of refinement during sort of a leasing and permitting process that plays out over several years. And again, reinforces the considerations that agencies use, the public input that goes into making determinations. This image on the left, this is of our South Fork wind farm, which went operational in the beginning of 2024. It's the actual farm is this little box here. Over a decade ago, the states had identified this larger area for potential leasing. The Bureau of Ocean Energy Management looked at it. They looked at a series of information overlaid with maritime transit corridors, fishing grounds, etc. And areas were carved out. So then, this large box became the smaller box. These red areas were excluded. So you can see here, we're already down, 25% or so are carved out. And then if you look at the layouts that were initially proposed, there were narrow spacing with public comment that was widened to a 1 nautical mile by 1 nautical mile grid to allow more ease of transit. So again, when you're building on public lands, whether onshore or offshore, the design that you have will change. And what, for some of these first projects through the energy transition, it was a challenge to determine, making sure that you avoided this circular loop, that making changes to a project to account for public input didn't change the impact so much that you'd have to go back and start. So a lot of this was done over the course of several years with robust public comment and a robust record, and the end result are better projects. And with that, I will now pass it over to the next speaker.
Thank you, Brian. That's great. I'll actually give you one question just to break it up a little bit between you and Samir. And so, Brian, you talked about the ITC, and it's heavily debated right now. What's going on with it? And I see the ITC as a subsidy, a federal subsidy that is alleviating a certain burden for the states. So how do you see the role of the ITC in renewable energy, solar compared to onshore, offshore wind? And if it's removed, how does that impact those different projects commercially?
Sure. No, great question. I'd say, for better or worse, a lot of our energy policy in the United States to date has been tax policy. And to the extent that these, whether it's the investment tax credit or the production tax credit stimulated investment, they do reduce the cost of energy. And they allow a more robust, because as I mentioned, they allow that capital to then be reinvested in new projects more quickly. So it does help meet some national and state goals. To the extent, this question of the subsidy is debated, again, there are a lot of technology-specific policies in place, whether it's liability caps on certain technologies or tax credits, all of which help reduce the cost of deploying that type of energy. So it's not necessarily, always an apples to apples comparison. I think you have to look at the full suite of policies that are in place to try to promote the rollout, and the tax credits are a key one for renewable energy.
And my understanding is that the cheaper the deployment, the lower the ratepayer will pay for the electricity.
Yes, I mean there have been some studies that come out that if depending on the technology, but if the tax credits were to go away and some aggressive timelines, there could be increases in power prices.
Thank you for that, Brian. And let's move over to Samir.
Thank you. Can everyone hear me okay?
Yes.
Oh, very good. And I'll just wait until my first slide appears, but to give everyone a preview, here it is. I'm going to try to walk everyone through the process of how new clean power gets built from the planning and ideation stage all the way until there's actual steel in the ground. And I'll try to walk through many of the legal and regulatory considerations that inform that whole process. A few disclaimers initially. I'm speaking just for myself, not for my organization. I'm also going to offer many sweeping generalities about public utility law across the 50 states and the District of Columbia and Puerto Rico. And of course, there will be many exceptions. The generalities do not apply to every state. But I think what I highlight often is the quintessence of how legal structures tend to work. I should also say that I looked at the registration list. I saw there's many seasoned, brilliant professionals on the list. And for some of you, I expect some of this will not be new information, but hopefully some of what I have to offer is informative. So firstly, in thinking about the electric power sector in the US, ownership of power plants is split between regulated retail utilities and merchant power developers. Now, in my years in the energy sector, I've heard merchant developers and independent power producers used with, at times, slightly different connotations to those two phrases, but I'll use those two roughly interchangeably. And as you can see in the graph on the right, retail utility-owned power assets produced a little bit more than merchant power in 2024, but it's pretty close, in fact. And for comparison, Brian talked about this a little bit earlier, 1 megawatt hour is approximately how much electricity one household uses in 1 month. So what's a retail utility? Everyone here likely has a local utility. Under state law, typically, there's a statute that says a utility has an exclusive franchise to serve a particular area. The utility gets all the captive customers who live in a defined area. Here on the page, I've provided a couple examples of statutes from Indiana and Arkansas. If you look up your own state, likely there's a similar statute that provides exclusive authority to utilities, incumbent utilities, to serve particular areas. Or sometimes the utility, sometimes the statute says all utilities who served customers as of 1983 shall continue to have exclusive access to serve that same territory forevermore. A further question to ask is, if an incumbent utility has exclusive access to a captive customer base, what service is the incumbent utility providing? Traditionally, in the 20th century, all retail utilities were vertically integrated, meaning a single utility in a particular area owned the power plants and the transmission wires and grid and the distribution wires and grid. Starting in the 1980s and 1990s, as free market economists began to gain sway with decision makers, some states, which you can see here in the map, some states began to deregulate their generation sector and require the separation of ownership of power plants from ownership of the wires. So today, in, for example, Texas, Illinois, California, and New York, to name some big states, and some somewhat smaller states, generation is largely a merchant function. It's not owned by the retail utilities that have the captive customers. Generation in those states is competitive. And as I'll discuss later, there are different considerations when a retail utility is planning the construction of new generation versus a merchant developer, as Brian walked us through, is considering the construction of new generation. And by the way, this map from a US EPA website shows that Montana is deregulated. Montana is an interesting case. They deregulated in the late 90s, and then in 2007, they passed a law to partially re-regulate, so the utilities reacquired many of the power plants. It's still a confusing case to me today.
Samir, can
yes.
I ask a quick question on behalf
Yes, of course.
of our listeners? Back at your previous slide, one of the attendees are just wondering what the difference between distribution and transmission is, and I thought that was fitting.
The difference between distribution and transmission. This might be I think I need to go back, okay, to this slide. This might be a better question for an electrical engineer to answer. One way of answering is the voltage. Voltage on transmission lines is higher. It's used for sending electricity over very long distances. And distribution lines tend to be closer to where the actual customers, homes, commercial facilities who are taking the power actually are. So if you look outside your home and you see a wire coming into the side of your house, that's a distribution line coming from a pole down the street. That's my non-engineer's understanding.
Thank you.
Now, retail utilities have a state-regulated revenue requirement that gets paid by their captive customers, and that revenue requirement is set by the philosopher kings on the State Public Utilities Commission. So if we're talking about a vertically integrated utility, which, as you'll recall from the map on the prior slide, is in most states, a vertically integrated utility has generation assets and transmission assets and distribution assets. And when it comes to the State Utility Commission for a rate case to set its revenue requirement, the utility says, we've got all these assets. The assets have some investment value, net of depreciation that has occurred over time, and we deserve X% return on our investments. We also have all these expenses, and we deserve one-for-one revenue recovery to cover the expenses we made. And the utility should consider what are the prudent and reasonable expenses of what the utility is proposing. And then the PUC, after a lot of debate and a lot of math, comes up with an annual revenue requirement for the utility, often in the range of hundreds of millions of dollars or billions of dollars. And that revenue requirement gets allocated to various customer classes according to considerations usually of cost causation, who's responsible for driving different investments. And usually when a retail regulated utility builds a new power plant, which is the focus of my talk here, usually the investment value of the new power plant gets folded into the utility's overall rate base. Rate base is fancy industry lingo for the overall investment value of all the assets the utility has. And therefore, the cost associated with the new investment gets folded into overall revenue requirement, and all customers share the responsibility for that cost. Now, there are some, in recent years, more innovative cost allocation structures I've seen, where especially if one single new large customer is responsible for driving the construction or procurement of a new generating asset, there are ways to allocate all the cost of the new generating asset to maybe one large customer. But that's relatively novel and unusual. Now, because retail utilities are responsible to serve the demand for all their captive customers, state laws and state regulators give them the responsibility to meet demand at all times, all hours, all days, and all years going forward into a planning horizon. And to that end, many states, not all, have created an integrated resource plan process, which requires the retail utility to consider demand going out 10 or 20 years into the future, to consider all sorts of economic variables as well as demographic variables. What will be the population growth rate in 2035? What will be the price of natural gas? What will be the price of coal? What's the cost of maintaining our existing generation fleet and giving it any required environmental upgrades to stay ahead of natural wear and tear as well as regulation? What's the cost of investing in new generation? Also, can we consider non-generation investments to meet demand, like demand-side measures, energy efficiency, distributed generation, demand response? Also, can we invest in our transmission grid as an alternative to investing in generation? So in the integrated resource plan process, which, by the way, if you look at the map, even states including California and Illinois, where generation has been separated from distribution and transmission, even in California and Illinois, there's some form of a planning process, although contra what this map has to say, I wouldn't quite call that integrated resource planning, but there is state-led planning. So in vertically integrated states, the vertically integrated utilities consider all of these factors, and then using complex modeling software, the utility creates portfolios, which means in every year going out 10, 15, 20 years into the future, a portfolio includes a set of resources for 2030 and a set of resources for 2031 and 32 and so forth. And creating those year by year portfolios, which comprises a single longitudinal portfolio, could entail retiring certain of your existing assets that you have today and building new assets in the future. Portfolios must, as evaluated by the very complex software that IRP modelers use, must be able to meet demand in every hour, sometimes even every minute of every day of every year going out into the future. There are also often green goals that legislatures have layered on top of a simpler IRP modeling process. For example, on this slide, I've quoted a Michigan law that says the IRP should promote environmental quality, mitigate adverse effects on human health, prioritize benefits to communities who have been disproportionately impacted. So in the construction of a portfolio, as well as the State Regulatory Commission's review of the proposed ideal portfolio that the utility ultimately submits, additional criteria such as this one will be considered. So ultimately, in an IRP process, the utility considers different portfolios that meet all the goals and constraints that state law and sometimes commission rules have set forth. And then the utility adds up the cost of the different portfolios. And sometimes the decision rubric is simply which compliant portfolio is cheapest. We'll go with that. Sometimes there's multiple variables to optimize, including sustainability considerations. But the ultimate end game of an IRP process is to find a single preferred portfolio that the utility will submit to the State Regulatory Commission for consideration. Sometimes the State Commission in a litigated case will approve or reject the IRP. In other states, the utility merely files the IRP for the information of the Regulatory Commission. But in all the states on that map I showed a couple slides ago, the utility is required to at least go through the exercise. Now, this slide here shows the recent result of the Duke Energy Indiana IRP 2024 IRP exercise. And how do we interpret all these bars? You can see on the vertical axis on the left, the 0 mark. Any bar that's going above 0 represents new construction of generation. For any part of the bar going below 0, that refers to retirement. And in 2030, it looks like there's 7 portfolios they considered. Each one has a code name, like Blend 1, Blend 2, Blend 4. And they considered the same portfolios in 2035 and 2044. Each portfolio has a longitudinal character. Each portfolio describes what the resource mix will look like in each and every future year. So in this graph, you can see that by 2044, there's quite a lot of new construction, up to 15 gigawatts, it looks like, and less so by 2035, around 5 gigawatts of new construction by 2035. And you can see that Duke Energy Indiana is proposing to retire a lot of their existing coal fleet that exists today in 2025. And now I'm going to take a little bit of a detour before I get back to the question of how do regulated utilities decide to build new generation. I'm going to detour to something called regional transmission organizations. I'm sure many of you are familiar. FERC, the Federal Energy Regulatory Commission, began to encourage the creation of regional transmission organizations with an order called Order 2000, which came out at the end of 1999 when the Backstreet Boys and Will Smith were ruling the charts and everyone was worried about the Y2K bug. FERC had the Millennium bug, so they came out with Order 2000, which is codified at this citation I gave here. It didn't require transmission owners to join RTOs, but it very strongly encouraged them to join RTOs, or else explain why they were not going to join RTOs. And the basic concept of an RTO is it's an independent entity, independent from the utilities that own transmission wires, that's going to manage the transmission grid, including dispatching generation, as well as interconnecting new generation at the transmission voltage level, to get back to a point that I made earlier. Now, this map shows how a few regions are organized. The true RTOs on this map are the California ISO, ERCOT, which is Electric Reliability Council of Texas. In the middle of the country, we have Southwest Power Pool, SPP. MISO, the Mid-Continent ISO, is in the middle of the USA. PJM is in the Mid-Atlantic, extending to Ohio and parts of Indiana, Michigan, and Illinois. Then you have the New York and New England ISOs in the Northeast. There are, as you can see, other regions that are not true RTOs, although this FERC map has labeled them as such. Now I'm detouring into this issue of regional transmission organizations because while it is true that, as I said a few minutes ago, regulated retail utilities have a responsibility under state law to maintain resource adequacy, in other words, to provide enough generation to meet demand at all times. Increasingly, in the last 2 decades, RTOs have taken on the legal responsibility to do just that as well for the whole region. The Federal Power Act doesn't exactly say that RTOs should do that. Order 2000, which incentivized or encouraged the creation of RTOs, also does not say that. In fact, in 2005, the US Congress passed the Energy Policy Act of 2005, which created a new section of the Federal Power Act called Section 215, which has a couple passages specifically saying this new Section 215, which covers transmission grid reliability, shall not be interpreted to give FERC authority over resource adequacy, and it shall not be interpreted to take away the state's traditional resource adequacy responsibilities. Despite that, in recent years, or in the last 2 decades, multiple RTOs have convinced FERC that they ought to have the right and responsibility to run annual capacity auctions to, at a very minimum, measure how much megawatts of resources are available in the coming year to serve projected demand across the whole region. Now, for the most part, these capacity auctions don't impose a requirement on load-serving entities to bring X amount of megawatts to the table. Rather, if load-serving entities come short of their allocated demand responsibility, if they come short capacity to the capacity auction, usually what happens is that they are required to pay for the short amount of capacity at whatever the auction clearing price happens to be. So it's not quite the stringent requirement that states place on utilities or load-serving entities to meet demand. And at the bottom of the slide is a US Court of Appeals for the DC Circuit decision from 2009 that upheld FERC's authority to require or approve the function of RTOs to monitor resource adequacy in this way by running annual capacity auctions. What I have here is a slide MISO, the Mid-Continent ISO recently released, showing the result of their 2025-26 capacity auction. This one is actually for the summer 25 season because MISO does seasonal auctions. Basically, MISO constructs a demand curve based on the assumed value of reliability, or I should say the assumed value of resource adequacy or the value of lost load. And then resources submit offers into the auction where resources say, a resource owner of a 1,000 megawatt power plant might say, sure, you can have 600 megawatts of my plant at $10 per megawatt day. And then you can have the next 400 megawatts of my plant at $30 per megawatt day. And adding up all those bids, MISO constructs a supply curve, and where the supply curve intersects the demand curve at a very, very, very simple level is where we have the auction clearing price. Now, in addition, when MISO runs its capacity auctions, it assigns an accredited megawatt value to every resource technology out there, and PJM does the same. The methodologies for capacity accreditation could be a whole 2-hour seminar, but you can see on this slide, gas and nuclear and storage receive, generally speaking, from PJM and MISO, higher accreditation ratings compared to wind and solar. So if you have a 1,000 megawatt nameplate, let's say solar facility in MISO, then in the summer, your solar facility would receive an accredited rating of 450 megawatts. As a further disclaimer, this chart that MISO prepared is based on a new methodology that actually has not been implemented yet for 2025-26. But what I'd like to do now is go back to the question of utility planning. If you are a utility laboring under your state regulatory regime, you still have to pay attention to what the RTOs are doing. This, for example, is an excerpt of an Indiana statute, which basically says when Indiana utilities do their IRP planning and they try to match their available resources against demand, they have to use the accredited rating of their generating resources that MISO or PJM, as applicable, gives to it. So the RTO policy making resounds quite strongly at the state level. So let's say your IRP is finished and you've identified a least cost portfolio, and perhaps the state regulators have blessed that. And your least cost portfolio calls for building new generation, let's say in 2026 or 27. What's next? Well, in many states, what I have here is a partial list of states. I don't think this is a complete list. In many states, there's still an additional regulatory step where you need to go to a state body like the Public Utility Commission, or in some states, it's something other than the Public Utility Commission for permission to build your new generation. And often many of the same arguments that reverberated in the IRP process still get debated back and forth in the litigated certificate of public convenience and necessity process. Let's say you get through all that. One additional element to consider, and here's why I've put the RTO caption back on the top of the slide, is you have to apply to the RTO to interconnect your generation, your new power plant, to the transmission grid. And ideally, as the project owner, you'll start that process probably before you apply to the state for your certificate of public convenience and necessity. The reason being, as it shows on the right side of the screen, for the last few years, interconnection cycles are taking up to 5 years from the time of first application until any required transmission grid upgrades are built and all the studies of the electrical engineering effects on the grid that would be caused by the new generation are completed. So it's a long process. The RTOs are working on speeding that up, but it's a long process. You have to get in the queue fairly early. And these graphs prepared by Lawrence Berkeley National Laboratory show that in 2023, there was 2,600 gigawatts in nameplate capacity of new generation or planned new generation in RTO interconnection queues, which is about twice as much as the actual amount of real life generation that's already operating. And on the right side of the screen, that's broken down by RTO. I know I'm running short. I'll try to just spend 2 more minutes on everything else I have to say. I thought this here is interesting. Once you get past everything I previously said, now you're ready to actually build your power plant. You have land, you need to secure contracts for the equipment, you need engineering, design, you need a construction contractor. So you get all that locked down. Make sure that your labor practices comply with the requirements for federal tax credits, as Brian was discussing. So you've got all that locked down. And then this slide from a US DOE webpage shows all the steps that a developer, and this would apply to a merchant developer as well as a retail utility that's developing new generation. These are all the steps that need to happen for actual construction to happen. And on this Gantt chart, actual construction, as you'll see, is just a relatively small part of the full construction timeline. And then finally, I talked at the beginning of my talk about merchant projects. Many of the project development elements I went through are just the same for a merchant project. Now, one thing that's different is because a merchant project cannot rely on captive customers. It cannot rely on state regulated revenue requirement. Therefore, merchant projects want to lock in, as Brian was discussing, guaranteed revenue streams through power purchase agreements. Also, merchant projects typically borrow from the capital markets via project-specific financings, where the collateral security or the recourse the lender has is the project asset itself, not, as in the case of when a utility issues bonds to Wall Street, the recourse is not the whole utility company. Just one final point. We know in several states, including Illinois and New York, which have deregulated generation, they also have very aggressive clean power goals. Here I've excerpted a couple statutory pieces showing the clean power goals in those two states. But if utilities don't own their own power plants, then how are these goals to be achieved? Well, as Brian alluded to, in Illinois and New York and other states, state agencies do competitive solicitations for new renewable generation for REC contracts, renewable energy credit contracts, which is one form of assuring a long-term revenue stream. Now, the REC contracts are not for energy. They're just for the intangible environmental attribute element associated with the energy. This slide here shows the result of a recent Illinois Power Agency REC solicitation. You can see a couple solar and a couple wind projects were the selected bidders. These, of course, have not been built yet. This procurement happened in 2024, and I'm sure they have a long road ahead of them to get built. This is a similar results announcement of a NYSERDA, that's like the equivalent New York state agency that also does REC solicitations. This is the result of a REC solicitation they did last year. And that's all I have. Thank you.
Great, Samir. Thank you very much. I'll actually give you a question too before we move on to the next speaker, since I have two questions that are similar and deals with capacity auctions. So we have one question from one attendee asking, since the RTOs have asserted their need to auction capacity, have the ratepayer benefited or have these systems shown improved operational efficiency? That's one. And the other one is, how do RTOs, ICOs that encompasses both regulated and deregulated retail markets reconcile the differing incentives of vertically integrated utilities and IPPs in capacity auctions?
That is a very good question. I don't have the historical knowledge to really say how operational efficiency or reliability in the RTO era have compared to the pre-RTO era. There's also some confounding variables because there's been more emphasis in the last 2 decades on hardening the grid against storms and doing more tree trimming, for example. So all of these efforts, I think, have led to pretty good operational results for utilities. I'm not quite ready to attribute causality to what the RTOs are doing. I think overall the RTOs are doing a good job. Now, Chris, you also mentioned the issue of RTOs like, let me go back. Oh yeah, on this graph, MISO, for example, includes Illinois, which has deregulated generation, but most of the rest of MISO is vertically integrated states. PJM, on the other hand, is mostly deregulated generation, but then West Virginia, Kentucky, and Virginia are vertically integrated. And the theory of capacity markets is that the auction clearing price every year should give some incentive for new entry, new construction. That incentive is not quite as strong or not quite as salient, maybe might be a better word, in the vertically integrated states, where utilities build based on IRP processes, not based on merchant developers seeing revenue opportunity. And in fact, I agree that the match is not always perfect. The alignment of the incentive is not always perfect. I don't have a great answer for how to resolve that somewhat imperfect alignment.
Perfect. Thank you for that answer, Samir. And now we'll move over to Travis.
Thanks, Chris. As we await the slides, I'll just start off by saying that I'm going to talk about what's sometimes called fossil energy, what's sometimes called conventional energy, specifically the federal permitting and leasing regimes for oil and gas. And we've only got about 20 minutes. And the cliche is that we just hit the wave tops, but this is going to be like hitting the sea foam spritz in a martini. So it's going to be very high level. So I echo Samir's apologies to anyone who is really well versed in this field. And I've asked Chris to kind of interject with questions along the way to keep this conversational. So I'm going to hold you to that, Chris. And hopefully we can have a dialogue in the next 20 minutes. So let's go to the first slide. So I want to talk about just some general dynamics that cut across the federal regimes broadly. Then we'll talk about first onshore and then offshore. And that is how the Department of the Interior, which runs most of these leasing and permitting regimes, thinks about these programs, dividing it up between, terrestrial, onshore leasing, and then the leasing that happens in the Outer Continental Shelf. We'll touch on permitting a bit. That applies to both those regimes. And then we'll talk about where we think oil and gas is going to go in the next 5 years or even sooner. So let's go to the next slide. Talk about dynamics. Brian had his little quiz for each of these parts. I will just ask if anyone can identify the picture in the lead slide. Does anybody know what this is? Resembles a children's toy.
We have one thing.
No, Kenneth. So the colors are wrong. It's not NH4. Yes, it's methane. So the standard colors are wrong. This is a methane molecule. Natural gas is mostly, but not entirely, methane. It's a big part of especially onshore regulation. So let's go to the next slide. Okay, so when we think about the federal permitting and leasing regime for federal fluid minerals, there's 3 or 4 very broad dynamics that I think are interesting in this field, especially for lawyers. So the first is that it involves the intersection of contract law with public law. These resources are developed through leases issued by the United States to lessees. And so to that extent, they're governed by a lot of the contract law you learn about as a 1L. It's a little bit different when the United States is the lessor, but it's the same idea. But meanwhile, the leases themselves, the permits, these are final agency actions under the APA. The constitutional law applies. You get constitutional issues all the time in this field. And federal courts are still figuring out 100 years later, more than 100 years later, what the precise intersection is between contract and public law. So the APA postdates the Mineral Leasing Act, for example. And if anyone's been following the grant litigation that's gone all the way up to the Supreme Court, you know that appellate courts in particular are still trying to suss out precisely what claims for relief are contractual and which are a matter of statute and the Constitution. So that's an issue we see litigated all the time. Second theme, surface v. subsurface. This one's more technical. But in short, the United States began by owning most of both the subsurface and the surface rights to its estates. And then over time, it's sold off some of those surface estates and retained the subsurface rights. So you have private land overlaying mineral estates. You also have different federal agencies managing the surface, even where the United States has retained title. So BLM, Forest Service, Reclamation, tribes, private landowners. And so that makes the actual leases and the permitting pretty complex, especially with the advent of directional drilling onshore, which has allowed for a much higher percentage of what's sometimes called fee-fed drilling on onshore, where the drilling begins on private land held in fee, enters through private minerals, and then finally reaches and taps public minerals. Number 3, I hinted at this above. The Mineral Leasing Act is over 100 years old now. It codified some common law doctrines on mineral development. That is a world away from 21st century administrative law, both in terms of legal doctrines, but also in terms of just the way that statutes and regulations and cases are written. And we see very frequently courts and litigants having a difficult time kind of wrapping their heads or grappling with how to apply some of this older arcane language to kind of contemporary standards of review. So that's a really interesting topic that cuts across the field. And then number 4, I think, a lot of people come to this niche with or from kind of a land management or resource management or pollution control view. And all those are true and valid. But I think practitioners know that one thing that's driving a lot of the decision making on the ground is the money, is the financial terms. For leases, for federal leases, that usually means bonus bids to acquire the lease, the actual winning bid to acquire a competitive lease, rents on acres before production, and then royalties on production, and then finally bonding amounts for reclamation. So following the money here and being attentive to the financial aspects of leasing is really important if you want to understand the scope of the law and everything at work here. So just keep those in mind as we move through the slides, which brings me to the next slide. Okay, does anybody know where this is? It's in the United States. Okay. Texas, yes. So I actually don't know where in the Permian this is. This is the Permian Basin. It's been very productive, especially with the advent of directional drilling over the past couple decades. This region is actually starting to decline a little bit at the margins, but it's still been a hotbed for a lot of federal leasing activity, particularly in New Mexico. Next slide, please. To wit, here is a map of the federal mineral estate. So the brown is BLM administered subsurface minerals. So that's the subsurface estate I described. And the Bureau of Land Management essentially manages all of that. Now the yellow is the surface management by BLM, and almost all of that also includes the mineral estate below. But some of the brown, where you don't see the overlaying yellow, that surface area will be managed by other federal agencies. So the takeaway here, just a massive amount of land, especially in Alaska, especially out west. And when we use the word minerals here, it's not just oil and gas. It's also what we sometimes call hard rock minerals or coal. But at least at a broad level, all of this is open for business. That the qualifications are important, and we'll get to that beginning in the next slide.
So Travis, I have a quick question looking at the subsurface versus the surface. You made a reference to it a little bit earlier too, but what's your experience when you look at the coexistence between, for example, subsurface development of natural resources in general versus or in conjunction with the development or construction of surface renewable energy?
Yeah, it's a great question. Directional. So the tension used to be a lot more acute before directional drilling. A lot of the statutes for mineral development or for energy development in general, whether it's the Geothermal Steam Act or the Mining Law or the Mineral Leasing Act, the statutes and the regulations contemplate mixed use and try to anticipate competing claims. Where there's a real physical impracticability, usually it's like, most property law, whoever's there first kind of has a superseding right. That's essentially, I'm oversimplifying things, but that kind of is the simplest heuristic to use when you're thinking about how conflicts are resolved in law. Whether or not conflicts exist, in fact, with the advent of directional drilling, it's a little bit easier to do mining and oil and gas. It's a little bit easier to do solar and oil and gas. You still don't see a lot of it in practice. For a given acre, it usually has one use, and that is in part due to land planning, which we'll talk about in a bit. But I will say, generally speaking, some potential for conflict. In practice, there's not a lot, just because folks don't take those swings. And when there is conflict, there are actually decent legal mechanisms for resolving those disputes.
There you go.
But great question. All right, let's go to the next slide. Okay, so there are actually many statutes that govern oil and gas leasing on the onshore estate, but the biggest and the most important is the Mineral Leasing Act of 1920. And that essentially makes, you'll see here in 30 U.S.C. 181, both deposits and the lands containing those deposits, so you're getting at that subsurface surface distinction, open to oil and gas leasing. But then you'll see this important exclusion: national parks, the National Petroleum Reserve in Alaska. It was initially called the Naval Petroleum Reserve. Now it's the National Petroleum Reserve. And then private villages and incorporated towns are off limits. But in general, it casts a pretty wide net. And the next section I've quoted here, 30 U.S.C. 226, actually dictates how lease sales unfold on those lands. So the first thing I'll note here is that there is some tension between subsection A, which recognizes a deep vein of case law recognizing the executive branch's discretion to dispose of property after an appropriate delegation of authority by Congress, with subsection B added during the 1980s as a later amendment to the statute, which indicates that leases shall be held at least quarterly in certain states. And that tension between the Secretary's discretion and this requirement to hold leases quarterly, if you followed the litigation over the Biden era pause of oil and gas lease sales, it's that tension that was at issue and a lot of the litigation, and it's still kind of an open question. One clue about how that might be resolved, which I'll talk about in the next slide, is this qualification here that lease sales shall be held where eligible lands are available. And we will talk about that in the next slide, which we can get to now. So what does this mean in practice? How does that section work in practice? Well, it begins with land planning under FLTMA. So the Mineral Leasing Act predated FLTMA, but when FLTMA came along, it provided a mechanism for BLM to kind of determine, and the Forest Service to determine for any given acre what that acre's preferred use would be as part of it, the agency's obligation to manage for multiple use and sustained yield. So the first thing that happens is the relevant agency kind of sits down and they look at the land in a particular state or a particular portion of the state, and they figure out if oil and gas is a suitable use for that particular acre. And in general, in the aggregate, that's what most courts and observers have where they've attached this eligible and available qualification from the previous slide. Usually eligible means that it's subject to, or it's open for oil and gas development as part of the land use planning process. And available means that additional site-specific NEPA and other environmental review has been performed after the land planning process. And that site-specific review is important for point number 2 here. After the land planning process, BLM will actually hold a lease sale. In the normal course, interested participants will nominate parcels for sale. Then BLM holds a competitive auction. There used to be non-competitive bidding. There might be non-competitive bidding again after reconciliation. But for right now, at least, it's competitive bidding only. And the lease forms for those sales will, specify, as I indicated up front, rent, royalties, and the bids are, of course, determined through the competitive process itself. So after a lessee wins a parcel through a sale, then BLM enters the permitting and production phase. Lessees will submit what's called an application for a permit to drill. Once that is approved by BLM, and BLM is, again, they're running the normal permitting environmental review process, which we'll talk about in a bit. The APD gives the lessee a certain number of years to actually begin drilling. And once they begin drilling, the APD is essentially perpetual. It can be modified by BLM in certain circumstances, but basically, once you have a permit, it's presumptively good for the life of the lease. And when production starts, as I mentioned, that the lessee begins paying royalties. And then when the lease is terminated or canceled or abandoned, the lessee is obligated to reclaim the lease. And after they've done that, BLM releases the bond that's ordinarily collected for the lease. And this implicates issues of financial assurance, adequate bonding. It gets complicated when bankruptcy is involved. If you've heard the phrase orphan wells, what that refers to is wells, usually very old wells, where there's no responsible lessee identifiable to reclaim the well, which can often be leaking methane and other pollutants. And in the IIJA, the bipartisan infrastructure law, this is where the Orphan Well grant program came in. To the extent that federal land was involved, it was mostly Forest Service, not BLM. But I think the key thing here is to remember that, you know, the leasing, a lot of the litigation and controversy about oil and gas leasing goes to the lease sales themselves. But permitting and the kind of postscript phase, the reclamation and release phase of the lease is also really important. Next slide, please.
I have a quick question for you,
Yep.
Travis, on that specific issue on onshore development. Over the, the current administration is expressing a desire to produce more oil and gas in general.
Yep.
But if you look over the production in the Gulf over the last 3 administrations, it hasn't really increased very much at all. It's been about 1.9 million barrels per day. So what's your experience when it comes to increasing development, oil and gas development onshore?
Well, the leases themselves, the granting of leases themselves obviously doesn't result automatically in production. There's still a permitting process, which we'll talk about onshore in a little while. But at the margins, what developers will look for from the agencies is the type of business certainty that will increase production in the medium term. So if you know that there's a pipeline of lease sales in front of you, if you know that BLM or BOEM, which we'll talk about in a bit, can process your drilling permits expeditiously, if you have certainty about royalty rates, rentals, suspensions, things like that, it makes a difference at the margin in the same way that business certainty always makes a difference. But these things are not the proximate drivers of production. Instead, oil, gas is a global market, sensitive to geopolitics, sensitive to interest rates, sensitive to capital discipline. So administrations do have very powerful tools, but assuming that there is leasing, they're not going to be the whole ball game there.
Thank you.
All right, so let's talk about offshore quickly. This might be the hardest or the most difficult picture to guess of those on my slides. Does anybody know what this is? Okay, the silence is gratifying. This is a cap and stack. So if there's an offshore well with a blowout, this piece of machinery, which is the scale is kind of hard to tell here, but it's about the size of a small house or a condo, is lowered onto the well, and these kind of valves running perpendicular to the main trunk are rams, shear rams, which can seal the well and hopefully prevent something or stop something like a deep water type disaster. So they're really incredible pieces of machinery, and they're all kind of located near the Gulf itself, so they can be transported out to rigs in the event of an emergency. But let's go to the actual slides themselves. Okay, so the Mineral Leasing Act governs most of onshore leasing. Offshore leasing is governed by something, a statute that came about a half century later, called the Outer Continental Shelf Lands Act, which begs the question, what is the Outer Continental Shelf? So in short, it extends generally about 3 miles from the seaward boundary of states up until the jurisdiction of the United States. And that is in general about 200 miles right now, although in 2023, the Department of State acknowledged that the US recognized something called the Extended Outer Continental Shelf, which goes beyond 200 miles seaward of the shoreline. It's the Outer Continental Shelf Lands Act. So for the second bullet here, what it's really doing is it's leasing the submerged lands in the OCS. Obviously, oil and gas development needs to use the water column and the surface. But what they are actually leasing is a right to develop energy resources using the lands. And their use of the water column and the surface is subject to actually a lot of competing statutes, but also provisions in OXLA itself that recognize, almost like FLTMA, a multiple use role for the ocean. And then finally, the Mineral Leasing Act on onshore governs oil, gas, and coal, and a few other leasable minerals. OXLA covers basically anything energy related. It's not just oil and gas. It includes solid minerals, renewable energy storage, and after the IIJA, carbon capture and sequestration. Next slide, please. And so yeah, sorry, go ahead, Chris.
Yeah, I'm very curious about co-use on the shelf, though, because that's a little bit of a different matter, and you just pointed to it a little bit in your previous slide about CCS, for example, and the renewable energy in general, whether it's offshore wind, and how do you see that developing now? I know there's some discussions about it and some projects moving forward on it, and BOEM is getting involved more and more in trying to put some guidelines and some rules down for that.
For offshore wind specifically?
For co-use.
Oh, for co-use, yeah. So it's interesting. Like a brief spoiler alert. Huge portions of the OCS have been withdrawn from use for oil and gas development by presidential memoranda. So when we're talking about potential conflicts, really what we're talking about is the Gulf of Mexico. And the wind leasing there hasn't really taken off, and BOEM thought really carefully about how to locate wind leasing areas relative to oil and gas development. The wind is obviously way closer to shore than a lot of the oil and gas development. So almost as with the onshore question you asked along these lines, while in theory there could be a lot of conflict, in practice there's not much. There is a lot of interesting interplay between CCS and oil and gas development, in part because the infrastructure is not totally dissimilar, and the pipelines involved and the rights of way involved are potentially usable for both industries. So that's less about conflict, I think, and more about synergies. But BOEM has yet to put out its CCS rule implementing the CCS regime required by the IIJA. So we'll see precisely how that plays out, and what we hope will be a notice of proposed rulemaking soon. A great question. So let's just look briefly at the size of the OCS. So the IRA, you'll see in this lower left-hand picture here, the Inflation Reduction Act extended the definition of the OCS to include the territories. Before the IRA, it didn't include the territories at all. Now those areas are leasable, at least to some degree for energy use. There are some interesting issues there. And you'll just see the massive red blobs around the mainland United States and Alaska. A lot of acreage there. But again, almost all of this has been withdrawn from oil and gas use. Really, when we're talking about prospective oil and gas leasing and development, what we're really talking about is the central and western Gulf of Mexico. So just kind of that tiny slice right in the middle of the picture. Next slide, please. Okay, so we talked about the life cycle for onshore leasing. For offshore, it's more or less the same, and I'd like to focus on the differences here. So first of all, instead of land planning under FLTMA, which is undertaken by individual state or field offices at BLM, for the OCS, there is a statutorily required 5-year program that provides a schedule of lease sales, in theory, nationwide. So you have one office doing one consolidated plan, one consolidated program. And traditionally, the view of the Department of the Interior has been that schedule is a ceiling on lease sales, so that if you yank a lease sale proposed by the program, no revisions are needed. But if you add sales, you would need to do a revision. And the process for this program is actually pretty onerous. It requires a lot of iteration, participation by the states, and every single 5-year program has been subject to challenge, most of which have been successful in the DC circuit. We can all see the platforms out in the Gulf, so it's not like those successful challenges have resulted in vacatur and a lack of development. But usually it's a pretty fraught process to actually successfully develop and defend this 5-year program. For lease sales, these are competitive, just like onshore lease sales are competitive. OXLA actually contemplates a lot of different auction mechanisms that are really interesting, especially multi-factor, which allows BOEM to consider basically qualitative variables when awarding lease sales. So, has the lessee proposed community benefit agreements? Have they committed to other environmental or relevant social actions associated with the lease? It's a broader, I think, more contemporary net than what the Mineral Leasing Act contemplates. For step 3, permitting and production, again, the lessee needs to submit a development plan. In general, especially these days, the permits, the planning for offshore drilling are vastly more complicated than onshore drilling. I mean, the technology required to do high temperature, high pressure drilling deep offshore, it's a completely different beast. So these are pretty thick, technically sophisticated plans. And what is different, another thing that's different about offshore leasing is that enforcement of the permits and the lease terms is actually handled by a separate agency, not the leasing agency, an agency called BSEE, the Bureau of Safety and Environmental Enforcement. This was a post-deepwater reform, basically to ensure that the fox wasn't guarding the henhouse. It's a bit unfair to BOEM, but basically they wanted kind of a cop outside of the building, the leasing agency, to ensure rigorous compliance with the lease and regulations, especially as applied to safety. And it's been pretty successful so far. The agencies can sometimes have a bit of friction, but they continue to work it out, and I think it's been manageable. And then finally, we talked about release and reclamation for onshore. The big difference for offshore is that the business model on the offshore side, a lot of times you'll have majors coming in and just investing the huge amounts of capital to kick off drilling offshore. And then as the lease moves further down the decline curve, the majors will assign the lease to a mid-tier company who then takes over. And those companies just objectively are sometimes more thinly capitalized. They're at slightly greater risk for default or bankruptcy. So BOEM actually requires that the assigning lessee is jointly and severally liable for any reclamation costs. And that hasn't stopped bankruptcy from becoming a real issue, a real thorny problem for BOEM and for DOI in the last 5 years. And there's a chance that actually becomes more pronounced and acute in the decades to come as some of this infrastructure starts getting long in the tooth. Next slide. Okay, part 4, permitting. Brian touched on this a bit. Does anybody know, this is like potentially harder than the cap and stack. Does anybody know what species of whale this is? Okay, northern right whale. Not fin. Not fin. This is the Rice's whale. Yes, Colleen correctly guessed. This is the Rice's whale, which is a very endangered whale in the Gulf. It's kind of the Gulf equivalent of the North Atlantic right whale, and it's the subject of a lot of litigation and regulatory action on BOEM's side right now, because its health and the health of its habitat will make a difference for vessel speed restrictions and other conditions on permits. So let's go to the next slide. In my experience, the net for, or the checklist for permitting is actually even wider than Brian's. I think that's probably in part because of all the onshore action I've seen. But it's not just NEPA, not just the NHPA, it's the Rivers and Harbors Act, the Clean Water Act, the Magnuson-Stevens Act, Essential Fisheries Habitat Offshore, ESA, the Bald and Golden Eagle Protection Act, the Migratory Bird Treaty Act. I include the question mark because there are interesting doctrinal issues about incidental take and whether incidental take permits are even necessary or required for these actions, but it comes up every now and again. Coastal Zone Management Act, Marine Mammal Protection Act, and so on. So, onshore, offshore permitting it is a huge part of the process, both at the leasing and at the permitting stage. And I don't want to use the phrase "sand in the gears," but this is what is actually, I think, the primary driver on the speed of leasing and the speed of development, which is why permitting reform and all the conversations on the Hill and the New York Times about permitting are so important to development of oil and gas resources. Next slide. So what are some issues that we've been looking at for the past 5 years and that we're likely to keep looking at? The level of analysis. When do you run those statutes? Is it at the leasing stage? Is it at the permitting stage? How do you allocate the issues? That's a constant source of tension. How do you account for greenhouse gases? Just massive litigation over the past 5 or 10 years, resulting in the vacatur of leases and in individual permits, which is a big deal if anyone's been following the development of the law of remedies in the APA context. A couple of weeks ago, the Supreme Court put out a really important decision called Seven County, which has 2 holdings, one of which, to oversimplify, means that in most cases, you're going to see agencies and project proponents disavow their capacity to take into account greenhouse gases when doing NEPA analysis and reaching decisions at the end of the NEPA process. It's a very complicated topic, a lot of game left to play. Courts are already starting to push back on Seven County, but it is an important decision that's going to make a difference at the margins. And then, as I said at the onset, surface, subsurface, what are an agency's obligations, permitting obligations, environmental analysis obligations, when, for example, the drill bit enters from private land and then actually enters public minerals? It's a gray area that remains to be definitively resolved. Next slide. Okay, the future, some issues to watch. I'm going to try to do this in like 60 seconds so we can get some questions. We can go to the next slide. Okay, land use. There's a lot of litigation over the Biden era pause and the Inflation Reduction Act. Congress just started mandating offshore sales. Are we going to see Congress basically starting to basically remove the land planning process from the agency's discretion? The Senate bill and the House bill for reconciliation are trying to do this. I think it's probably unlikely to succeed given the parliamentarian rulings we've seen in the past week, but it's going to be a dynamic that we'll see play out again and again in the coming years. What to do about withdrawals and monuments, which remove the capacity of DOI to lease certain land for oil and gas. It's another big subject of litigation. The Department of Justice just came out about 10 days ago with an opinion that purported to allow the president to trim monument designations. Chief Justice Roberts wrote a interesting opinion a few years ago that forecasts more litigation in this space. Okay. Sorry, I thought that was the cane, but I take the point and I'll try to run through this. Okay, that was the cane. There's a lot that's going to happen in the next 5 or 10 years, but happy to take questions along with my other fabulous co-panelists. So thanks, Chris.
You are very welcome. We'll invite back the other panelists. And one question that might actually be interesting for several of you to answer is about the NEPA. NEPA is, of course, central in a lot of things when it comes to permitting. But the question is as follows. NEPA is a decision-making procedural requirement for federal actions. Could you please explain that NEPA is not a permitting process and expound upon the relationship between NEPA and permits? Who wants to start on that? I guess Travis or Brian are probably the ones working on NEPA more than Samir.
I can start. I tried to put together an answer in text while listening, and Travis can jump in and correct me. I take the the questioner's point that NEPA is fundamentally a procedural statute, but in the context of energy infrastructure, it's a critical component of the permitting process. I mean, if you think through, taking a hard look, and particularly if you think about more complex projects, so not a FONSI, but if you get even an EIS, so a programmatic EIS, final EIS, it'll evaluate a range of alternatives. And then the conclusion of the process with the record of decision will usually include a selection of one of those preferred alternatives. And that could impact the size, the scope of the project. Spatially, it could also they also could have a number of conditions. So I think that the culmination of that process, the federal action is to allow development of a proposed energy project that can either be not going to allow that to happen, or to allow that to happen as proposed or as an alternative. And there's a number of conditions that are included in the record of decision. So in a way, even though it may not be called a permit, there are pages and pages of conditions and other components. So I think it's really integral. The other aspect is when there are for larger complex projects, we spoke briefly about the interplay with other agencies, and there may be other agencies, a host of other. Travis went through the list of statutes. The federal government, at least, works closely with states, but also with the fellow agencies to try to coordinate a number of those reviews, both from a timing perspective and avoiding some duplicity. While each agency has to follow its own statutes and guidance, the NEPA document can be a repository. It is often reviewed by multiple agencies. So from the offshore context, the Coast Guard is weighing in on navigation, and Fish and Wildlife Service as well. So even though there are separate processes for the individual statutes, it becomes the main document. So it may be a bit of a distinction without a difference.
What's your view, Travis?
Yeah, I think, gosh, it's such this distinction between process and substance. Like anyone who's practiced for a long time knows that distinction bedevils a lot of law, not just NEPA. But I like the way that Brian put it. In some ways, it's a distinction without a difference, especially for large capital-intensive projects. That a lot of developers, at least most of the developers I know on those large projects, I mean, they want good NEPA, right? Brian laid out the kind of the evolution of a layout for a wind lease. I mean, NEPA helps generate good ideas and an iteration there, and that's what the process I think requires. But the functional reality is that there's so much substance is generated as part of the process that it can't help build something of a box or limit the decision space for the agencies and give fodder to litigants who come in and challenge this on the back end. There's just tomes and tomes of material to be written on this subject. We're starting to see a real, renaissance or a reevaluation of NEPA, especially with Klein and Thompson's book. So we could do 3 hours just on this, but it's complicated. The distinction between process and substance is very complicated.
And since we're moving towards the end, I want to ask the same question for each one of you, and that's whether the current energy law regime within the topic that you talked about is well suited to the energy expansion or the energy coexistence or the energy transition. Can start with Samir.
Thanks, Chris. I just wrote an answer in the Q&A to participant Evan Amber, and along the lines of what I wrote there, we do have overlapping jurisdictions, as I discussed in my lengthier talk. We have both state regulated utilities and federally regulated RTOs that have some responsibility for resource adequacy. And sometimes one side will point the finger at the other, and the other side will point the finger back at the first side for dropping the ball on resource adequacy. It's also the case, as I wrote in my Q&A response, that the FERC regulated RTOs manage the generator interconnection process, and states don't really have a way of speeding that up. Even in New York, where there's a state specific RTO, I believe the state government has no oversight over that RTO. So that lack of alignment does slow things down at times.
What about you, Brian? How do you see energy law in general and the basics of it maybe lying in your field?
Sure. Well, I mean, if you look at certain markets, I mean, I'm just across the river from Virginia, where they basically need to build as much new generation capacity in the next decade as they've built over the last 100. Again, each region is different. Where I don't necessarily think that the if we had to create a energy law regime from scratch, we would do it maybe a bit differently. There's a number of you've got FERC licensing hydro, you've got BOEM and BLM and a number of different agencies, all with different equities, depending on the statute and the type of energy. I think the transmission is not something that we have touched on today. I think that is a huge part of solving, sort of going back to the demand spike that we're seeing. Ensuring, because really the part that has we've talked about whether it's energy coexistence or energy expansion. I will say the transition has been that we are seeing again new forms of energy. Again, the announcement earlier this week of New York trying to facilitate new nuclear. So we're seeing old and new, but what is definitely a transition is that renewables allow generation away from load. And so we need to be able to find a way to connect that load that will reduce costs. It will help with, alleviate congestion. It will help with ratepayers, and will bring new generation on. I think that, to date has it takes too long to build transmission now. So the long-winded answer to your question. It's probably not ideal. We kind of also have to deal with the regime that we have, and we also have been able to do quite a bit, even in a dynamic environment. And we'll make the best of what we've got to work with.
Travis, you get the last word.
Yeah. Oh gosh. You'll have to be fast because I have to hop to at 2:00. But I think that the short answer is no. I think that to the extent that we're exceeding in spite of, not because of the current regimes. I mean, these are old statutes that are just kind of heaving under the weight of the demand and the technological advances and the changes in the legal regimes. And folks are afraid to start getting in the guts of these and amending or reforming them because they're petrified of what that might mean. for stakeholders that are on the other side of the issues for them. And the result has been paralysis and stasis in some really key areas. And there are just a ton of room for improvement. I don't discount the ability of industry to kind of work through this in ways that are innovative and durable, but we're not making it easy on ourselves.
Thank you very much, Travis, Brian, Samir. Thank you so much for taking the time, and Eli for putting this event on. Have a good afternoon.
So I'm going to give a huge thank you to our fabulous speakers today. Thank you to Chris for moderating, and to Brian, Samir, and Travis for your engaging and insightful presentations. We so appreciate your time and energy, as well as your willingness to answer so many audience questions. Thank you as well to our audience for tuning in. As we said at the beginning of the webinar, this program was recorded, and the recording will be posted to ELI's website and YouTube page within a few business days. We are halfway through our summer school series this year, but we still have plenty more content coming each Tuesday throughout June and July. We'll see you next week, either online or in person at ELI's office in DC for our climate change session. The week after that, we will be back online for our Clean Water Act session. You can find out more information about summer school, including the registration links for all upcoming sessions at eli.org. We've also dropped the link to that in the chat. Lastly, programs like these are made possible with the support of ELI members. ELI membership is free for students. Members can attend exclusive member webinars. They also have access to our entire webinar archive, along with many other benefits. If you are not already a member, we encourage you to visit eli.org to join. Thank you all once again, and have a wonderful day.
Thank you. Bye.